Welcome to Big Blend Radio's California Employment Law Podcast featuring San Diego attorney Ward Heinrichs. Welcome, everyone. You know, Ward Heinrichs is on Big Blend Radio every fourth Wednesday, but he's hopping on early because it is time for his annual update of the new laws for California, his employment laws, right? And this is what's happening now. So I'm so excited to have him back on Big Blend Radio, and he's going to tell us all about these new laws that you need to know, whether you're an employer or an employee. But first, very much, both of us, I know, Ward, you're feeling the same way right now as this airs. LA is going through a lot in regards to wildfires, and so many people, so many business are affected. So our hearts are with you, Ward. Same way for you, right? This is I could barely even talk about this. It's so hard.
It's devastating, and I've been following the news and watching what's been going on. I do have some family up there. Have not heard from them. I'm gonna have to reach out to them this evening. The devastation's amazing. I mean, 10,000 structures they say are just burnt, and it's just you can't believe it. You just can't believe it, and the devastation, the pictures that you see completely devastated. And I just heard something on the radio yesterday talking about getting insurance companies to cover this. Um, there's all sorts of regulations and building and stuff, and that can slow this whole process down. And I know that some of the California legislature, are going to be working on that to make it more efficient. It's a trying time, but I am feeling good about people pitching in. I mean, again, the legislature I know is going to meet and try to make things more streamlined, and lots of other people, the firemen, firefighters are doing a great job under tough conditions. So yeah, it's bad.
It's bad, and I want to say Ward will be back on his regular time of every fourth Wednesday at 4 p.m. Pacific time. We're on early because, last year it was like, hey, we're at the end of the year. Let's go into the new year with what's going on. But he'll be back on with his regular time this month, and we're going to touch on what's happening for employers and employees, because there are some laws regarding what happens in these kinds of emergency situations. Are you
Yeah.
legally allowed to say, you know what, I'm not going to work, this stuff's going on, so that kind of thing. So we're going to talk about that at the end of the month, or the fourth week, because I think we have 5 weeks in January. We stretch out,
Yes, that's
just like
true.
my belly from the holidays. Just saying. But I didn't say that. I didn't say that. But really, everyone in LA, our hearts really are with you. So many friends and clients and podcast people that are on our shows are affected right now. And we love you all and support you, audience, as well. Yeah, LA is a massive city and county and is iconic around the world. And what's going on right now affects everyone. But we're going to get into California employment law for 2025 because, like, Ward, this is the big interview of the year. I mean, we talk about things all year long, but this is always the biggie. And this is the biggie of what is going on. So, when this is going to be, some is federal, some is this all federal, or is this all like California specific this
I
year? You've
think
got a
this one
great
I did
article.
only California. I don't
Ooh.
think I addressed any federal laws. I can take a quick look. No, no, no. It's all California law.
All right. So everyone, that link to his articles in the episode notes. You can also just go to blendradioandtv.com and just type in, Ward's 2025. You'll find it. And you can also go to bestemploymentattorneysandiego.com. Just got to say that. So what is this PAGA? It's not MAGA, it's PAGA. What is the Private Attorney General Act got to do with this year?
Yeah. Well, the Private Attorney General Act was first well, I think it was passed in 2003, and then what became an act of law in 2004. And the way it works is it gets individual employees who have suffered certain types of harm, or have suffered certain types of violations, um, are able to bring a case and collect the penalties for the state. And for doing that, then the employees who are make up that group of employees who've had this happen to them get 25% of what's collected. So on an individual basis, it's usually not a lot for the individuals to get, but it still is an enforcement mechanism mostly for the state of California. And what's happened was the the penalties got so great because they're calculated per pay period per employee. So if you have 100, 200, 1,000 employees, you just can imagine even at $100 a violation per week per employee, that can be a gigantic number. So, and businesses have been saying this is just too much. You're really hurting us, and the penalties are just too great. And they have to pay for attorney's fees, and attorney's fees can be large in these kinds of cases. So the legislature said,
Yes,
"Hey,
Ward. Just kidding.
we're gonna get you, yeah, we're gonna give you some relief businesses. And in fact, it's pretty significant relief because you can reduce the penalties by as much as 85%, depending on how you react to a notice of violations. And you can even possibly avoid it if you're thinking proactively and try to take care of these things in advance so that there aren't violations, or maybe there's just a few that have lingered over the year and they're about ready to hit the statute of limitations, which is 1 year. So anything older than 1 year, you can't collect on in these cases. Anyway,
Oh.
bottom line is there is a way now for employers to fix things, get reductions in penalties because you fix things, even potentially cure them completely and get off completely.
Okay, so the fixing thing, this is a good point, right?
Yeah.
Because it seems like sometimes these laws get into place because something happened. Then the law, someone goes and makes this law happen. People go, hey, y'all, this is bad. I'm in the South right now, so I say y'all. So I'm right in there. Sorry. But sorry, it happens. It just happens naturally. But they keep knocking on the door, and then this bill gets passed, and then it's so extreme. And we see this. I mean, that's why you're on the show all the time, because here's this big law, and then it doesn't work, and it really actually hurts business down the road, which means if it really hurts the business, it hurts the employees at the end of the line, right?
Job killer if your company is hit with one of these big fines. Of course, it depends on how big the company is. AT&T probably makes it through, but it could eliminate jobs even for someone like AT&T if the penalty is big enough. So it does hurt employees as well as employers, often,
Yeah.
put it that way.
Yeah. So now people can go back, make amends, right? So
Yeah.
isn't that better to make amends? Just saying.
Well, the idea really is to stop what penalties are going on, what activity that creates penalties from
Okay.
going on. And so the most important thing is fixing it. And I think the legislature said, yeah, we agree that that is the most important thing. And we don't want to just burden employers with huge amounts of money paid to cover fines. So again, you can drastically reduce them. If you go ahead and try to fix them, you might avoid them completely, depending on the number of employees you have. So it really does two things. One, doesn't become such it, or businesses can avoid the huge financial burden, or at least reduce it drastically, and the problem can still get fixed.
Mm. Okay. So what are the circumstances to have these penalties? I mean, is it every
Well,
kind of
there's
thing? I mean, is
wait,
this
mostly wage and hour things, like if you don't what was it? Oh, meals and rest periods. I mean, individuals can collect money from meals and rest periods if there's violations. And there can even be class actions based on meals and rest periods, but they also can create a PAGA case. And that means not only could you pay all the employees for the penalties that they can get themselves, not the state, them, and then also pay the state. Um, so I guess what I'm really saying is most of these are wage and hour types of violations that you see PAGAs about, which could be meals period, rest periods, can be minimum wage violations, overtime,
Wow.
pay statements, all sorts of things like that that are, violations that California is concerned with, that are fairly typical. You see these alleged fairly often, um, but that's the group we're mostly talking about.
What do you see as an employment attorney? I know you work with employees and employers, mostly employers, but what do you see as the biggest, like, uh-oh, that comes through your door? You know?
Yeah. Um, well, all right. So I think meal and rest periods is the real big one now. And
Oh,
actually I
really?
just got a
Wow.
PAGA notice for one of my clients. Um, and it alleged meal periods, rest periods, overtime, minimum wage,
Oh,
which can also all be penalties, as well as money that is owed to employees for violations. Seating. They allege that there wasn't proper seating, and that can be another penalty. And there were some others there, and I'm not recalling right
oh,
now, but
so like I remember being in a job where there was no place to sit. You had to go off the premises, basically.
yeah, for
Oh,
the typical seating case is something like
yeah.
a retail
Mm-hmm.
business where there's a cashier, and you know how cashiers standing and they're working away, and the law says, well, if there's some downtime, there has to be proper seating for them during that downtime. And if you look around, you see that, well, there are a lot of businesses still don't have that. And so that can be a potential PAGA violation. And it certainly can violate the law. Um, I'm seeing more and more, where retail places do have seats for cashiers, but not everyone.
So are part of what's going on a generational change, perhaps?
Yes, I think so.
Ooh, so that is like also going about what you say and do harassment wise, not like discrimination, not harassment, discrimination on age, because isn't that part of what happens in your field?
Yeah, age discrimination isn't a PAGA violation. It could be a class action. But I mean, do you
For
see?
you, like what do you see that? Do you see that happening?
I see the allegations all the time. Um,
Oh,
it can be hard to prove. It's not always the easiest thing to prove. Will depend on the situation. Yeah, just depends on the situation.
why can't we just all get along, Mort? Just, well,
Well, okay. I mean, maybe all these things should be common sense and we just take care of it as part of the marketplace for
but
whatever
we don't.
reason. Well, yeah. And then I think on the other hand, though, I think maybe California wants to protect employees to maybe a greater degree than really needs to be. Here's an example.
Okay.
Many people really don't want to take a lunch, especially in restaurants, because they don't want to
No,
clock
don't take
in.
me up. Don't take me down when it's the highest time to make my tips.
Exactly.
Hell
You're
no.
working, maybe a
Mm-mm.
5 hour shift, and you're entitled to a meal period if you work 5 hours, five
Oh no.
hours and
Really?
one
Just for
second.
five? Oh.
Yeah. And so even if you do a 6 hour shift, you're entitled to a meal period. But most people that I've ever talked to go, especially if they're in the restaurant industry, they go, I don't
I
want to
want
take,
mine at the
I
beginning
want
of
to
when
make
I
my
get there.
money. I don't want to,
Rather
have to
let me
take a
come in
rest
late.
period.
I want to come in late then. You know what I
And
mean?
and right, and then they want to, they'd rather work their six, come in, just work straight through, and leave.
Well,
And,
when I worked in
you know,
some retail where we got commission on sales, and your part of your income came from that, right? It was like a draw on like your sales, and it was a weird system, which probably wasn't would not be
very
legal
often there's an
in
hourly
California.
rate combined with commission, and so maybe you're talking
Yeah,
about
and
something
it's a
like that.
weird thing. And they would say you need to come in at this time, but I knew it wasn't a profitable time to come in. So I always like, well, screw that. I don't want to do that. I know I'm not going to make sales, but you're making me come in. And if I make a sale, it goes against that time frame that I was there, which was minimum wage. So, like, I want to come in and just make sales. I want to be commission only because I actually make more money that way. And so that was always a fight in that company. And they are not in business anymore because of that, because it was a scam. I
It
didn't
can
know
be.
you then. If I knew you and you were in Florida, we would have, I would have called Ward. But, anything goes in Florida. Just
Well, California is very protective. New York's very protective. And like I said, I think there's examples when even the employees think it's overly protective. I'd rather have more flexibility than the law allows me. I mean, another
yeah.
example of that is the gig worker economy, where the law that just changed. Oh, gosh,
Oh,
God.
you got a freelance one that just happened. The
Well, we do
freelance
have a
one is
freelance one now, but I'm thinking of
the
the
independent
law that
contractors,
yeah, the independent contractor law that created a new test, the ABC
the
test.
ABC test.
And
Yes.
the law that I wasn't remembering is AB5, and it's the ABC test. And many people who are working as independent contractors, depending on the industry, but many of the industry said, we don't want this. You've put us into this where it's hurting our
Both.
ability to make a living, and the employees, quote unquote, said we don't want it. And so the legislature did pass a law that changed that and exempt many different types of work from the AB5.
Thank you to Uber and everybody standing up and saying, we don't want that, because it really did. Like, the gig people want what they want when they want it.
Well, it depends now, because
Oh
they had
boy.
that other law. You
We
you,
went
you
into the
said,
weeds again.
yeah. I mean, you did mention Uber, and they actually got on the ballot, their own ballot measure that exempted them. And it's hard to say whether most employees there, workers there, wanted to be exempt from AB5 or not. I don't know. But they did get a lot of good concessions in the ballot. So it seems like it's working okay.
All right. So there's a freelance um, worker thing that's going on for 2025 that is in your article. And everyone go to blendradioandtv.com. It's linked in the episode notes, but it's called the Freelance Worker Protection Act SB 988. I'm being
Yep.
technical. And it requires employers to have contracts with independent contractors who earn at least 250 per engagement. Okay, so wait a minute. So this goes because how many remote workers are there now? Like, people go on Fiverr and all these things. Get someone to edit a podcast
So
for 250 an
common.
episode. So let's look at that.
Yeah, no, this is a very common work situation now that they're trying to address. They're saying, hey, if you are an independent contractor, you're exempt from AB5, and you're allowed to work as an independent contractor, but you make a certain amount, and then 250 per engagement, that's pretty low. It kind of depends on what type of engagements we're talking about. Let's talk about a band, for instance. If a band gets $500 per engagement and they go to the same restaurant, weekly, then they're going to have the law requires them to have a contract with that band. It's not just a handshake that's legal anymore. It has to be a written contract that talks about the terms of payment, the scope of the project, and the timelines. And so something like that really might be, well, you come to our restaurant every Friday for a year or 2 years, or one of us decides that we want to end this agreement. But we're going to pay you $500 and you have to be there for, 3 hours. So it'll be something like that. So again, this law will require it to be a written contract. That's the main thing.
Oh, okay. So it's a written. I love that for bands, by the way. Every time you bring up you bring up music, you're gonna have to shut me up soon. But as a music person, it used to be, oh, here, have your food and your beer and all of that, and that's not good enough. And so this is actually a protection for the band in a way, I think,
I
or
used the
not,
band
because
as an
some bands,
example.
But some bands will go, I want cash under the table. So shut up, Lisa. It's the same thing as legalized marijuana.
Okay.
So anyway,
I hadn't thought about that, but maybe that is an incentive for the band or whoever this independent contractor is, could be many different industries, to say, no, I just want to be paid under the table. And then I think the business, what I would tell the business if they call me up, I say, no, you better put that contract into effect. It better be in writing, and you got to spell
yeah.
out everything.
Well, let's look at virtual assistants, right? So a virtual assistant is they work nationally, internationally. They can do anything. And I don't know if they are like if they're based in California, do they do California law? Or if they're in, say, I'm right now in Georgia. And if I was a virtual assistant and I had a client in California, do I have to do California law? Like, is that kind of
Generally, in the United States anyway, the law of where the worker is the law that governs employment.
okay? So where you are.
Yeah, so you're working in Georgia, Georgia law would apply.
Well, all I know is our taxes suck because we do business everywhere and we have to adhere to business laws in every state that we do business in. And that's never
Well, you don't
fun.
have many employees though, do you? I mean, it's just
No, but we have contracts
you have contractors, sure.
internationally. And so we have to go through, and I don't want to talk about it on the air because you never know which
Yeah, your lawyer's
IRS
going to tell
person
you
may
to
be
be
listening.
quiet.
But yeah, no, they all go like, "Hello, if you're doing business here, you have to pay this, by this," and it's like, "Oh, was it worth
Oh yeah, I yes,
expanding into in this
I
county?
see.
Was it worth doing business here? Of course it is. It always is. But anyway, it's just funny. But you know, that's what I love about doing these shows with you is it gives people an idea of what they're getting themselves into if they're new into it, or if they're already in it and they may not know, as a business owner, like, oh, I better start looking at what I'm doing because, one day you could wake up and you know,
Yeah,
shapoopy.
yeah.
I said the
Call me.
shapoopy. Shapoopy. If you got the shapoopies, you call Ward. Anyway, that I'm just saying the business shapoopies. Now let's go to the reproductive loss leave mediation program. Wow,
Oh, you like that, huh?
I had to go there. Well, this is such an interesting thing where, wow, the country's at war on what happens in reproductive rights, and California is like, hey, we're doing something here.
Yeah, so it was either last year or the year before, the legislature said, hey, we're going to require mediation. Well, maybe not require it, but employers who have 5 to 19 employees have the right to avoid court and go to mediation to mediate the disputes that they might have related to the leave of that's in California Family Rights Act or the bereavement leave. So if there's an issue with an employee and you have between 5 and 19 employees, you can say, "Hey, we're going to mediate this. You can't file a lawsuit." So that seems, pretty good, pretty fair, I think. I've not done this. None of my clients have ever had this problem. At least
Mhm.
they've not let me know about it. But it's there. And it is pretty new, but they've extended it this year to bereavement leave as well. So it's
Mm.
not just for excuse me, they've extended it to reproductive loss leave. It's not just bereavement leave and the California Family Rights Act leave. California Family Rights Act leave allows an employee to take 12 weeks off for a serious health condition and other related
Wow.
things.
Wow. So it's giving the employees some time.
Well, it's really giving the employer the ability to avoid court and have an independent mediator decide who's right and who's wrong and determine, well, all right, so that's not right.
Yeah.
Mediation is where a mediator tries to get both sides to agree. So the mediator will sit there and say, all right, the employer says that there was no violation here. The employee says there was. Employer, I think you might be wrong because this law here seems to apply. They asked for it on time. I mean, what the defense do you have? And the employer might go, well, you know what? Actually, they misdated the request, and by the time we got it, we weren't able to react the way we want. So, it could go like that. And then maybe the mediator goes, all right, well, do you think you can pay $10,000 for this? And they go, well, don't tell them that, but say we'll give them something. And then they go to the next room and say, all right, employer, they said they're willing to give you something for this. You got to come up with a reasonable number. You asked for 150,000 and it's just not worth that much. And so the mediator goes back and forth and gets hope, and the goal is to get an agreement between the parties. So this is a mediation program, and that's what employers with 5 to 19 employees have the right to do rather than get sued for violations of
Well, because
bereavement leave,
because
CFRA
people can
leave.
also lie, right? Can
Well,
people?
this is just, they're trying to be efficient and not cause and not have extra cost for small employers. That's really what this is
Oh,
about.
and also the courts.
Yeah, and it helps the courts too. I agree.
Okay.
It
Now,
can.
what
Now, no,
happens to you?
but
What
but
happens
if
to you
they
as
don't
an
agree, if they
employment
don't
lawyer?
agree, hold on. If they don't
Oh, okay.
agree, if they don't
Then
agree, you don't have a deal, and then you go to court.
okay. When do you come in?
Well, usually I represent people in mediation,
Oh,
employers,
so you still
employees. I've
have
done
an
both.
employer. Okay, so you have to sit there with the mediator as an employment attorney on either side that you're on, and then there's a mediator trying to go, now everybody has should be nice, and you're like, hell no. you know,
Been in many mediations, put it that way. And the mediations I've been involved in have been either where there's a court case filed or where there's a wage and hour case filed with the labor commissioner. So I've done those types of mediations.
wow.
I've not done one of these, and many employers may say, we don't want to spend the money on an attorney for this. We'll just go see what we can do. And so that option's definitely there. But if you, there's nothing wrong with having an employment attorney
I would
representing the
want
parties
someone
either.
there to like even just in my ear, like go, hello, we weren't able to do that years ago. Like I want someone on my Bluetooth thingy going, hell no, or yes or no, you know what I mean? Um, and I
Yeah,
think
no,
it's a sensitive situation too.
yeah, for reproductive loss leave, I think that is, well, bereavement leave too. I think that's very sensitive, potentially. And if you have a serious health condition and you feel like you haven't been given the leave you're entitled to, I mean, that could be sensitive. All these could be sensitive.
It's all sensitive. I mean, because all is around grief in some way. And
Yeah.
grief is weird. Grief, people go, "Oh, you should be over it by now." And you're like, I'm fine. And then you think you're fine. Nancy and I, we went through something even as we record is actually an anniversary today of something really big. And, we'd go to a business meeting thinking we're fine. And I remember we were fine. And all of a sudden somebody asked one thing and Nancy went literally down on the floor, just down because of a loss that was just so big. And so that wasn't good. And I'm like, all right. It was actually in San Diego and we're at a meeting and I'm like, get up, we gotta go. It was embarrassing, but real, and I think it's a very tricky situation when we look at bereavement,
It-
all of that.
I agree. It
It
certainly
is,
can
it
be.
is, it is. And I think I feel like that's where HR plays a role in communication between everybody so everyone
Oh,
has an
I like
understanding.
that
No?
idea. I like that
Oh,
idea.
okay.
But you got to remember when you have 5 to 19 employees, you may not have HR.
Oh,
It's a
mm,
small
that's
it's a
small.
small business. It's not a big business. Now, bigger businesses obviously have HR. And some small businesses do it. It really depends how much money they make. If they make a chunk of money, they may have HR as well.
Well, there has to be some communication of understanding who your employees are, is my point.
Yeah.
And understanding
Communication
if they are,
between employer and employee is paramount, and
that's what I'm talking about. Yeah.
very often the lack of communication is the source of the problem.
And if an employee isn't heard, eventually they get like, screw you, and I'm going to go to court.
Yeah, yeah.
Eventually, people get to a point of reaction if they're not heard.
Where I see most employment cases filed is with someone who's been terminated.
Mm. And they've done a whole bunch, never got hurt, and then heard, not hurt, heard. Um, then they get terminated, and then they get mad.
And they're mad.
Retaliation. Yeah. Ugh. All right, let's talk about paid family leave,
Uh-oh.
vacation protection. Okay, so what's going on there? What's going on?
So when you go out on paid family leave, you have to apply to the state to get it. And
Mm-hmm.
that can be for various things. You can get it for pregnancy, you can get it for other things.
Mm-hmm.
But the problem is you apply for it and it takes 2 weeks for them to put it into place. The
This
state of
is the
California,
government or
the
the,
government, it's a government program, and
okay.
yes. Um, and so what was happening was employers are saying, well, you're out for these 2 weeks, but you don't have paid family leave yet. So we're going to deduct that from your vacation because you're out. And then the employees go, well, wait a second, I got my paid family leave. I shouldn't have to have used this vacation. And the employer goes, well, shoot, I mean, you were out and there wasn't any money, you wanted money, so this is the only way to do it. So now the state of California says, well, no, what we're going to do is allow the employee to come back and say, you know, that 2 weeks of vacation you made me use, I get it back.
Wow.
Yeah.
Boom.
Yes. And so then the employer has to decide, well, do we pay them anything for that time? Because there's going to be that lag, 2 week lag. Or do we just let them go out on
Vacation.
unpaid leave?
Ooh. So what's legal about? Like, what is the
Yeah, that's
legal
tough
thing
for
to
the
do?
employers. And you know what I don't know about this law
So this is
is
really new and weird.
whether employers would be required to cover those 2 weeks. I mean, I don't think the state would require it, but maybe they have a policy that covers it. So they would have to abide by the policy. And then after they pay them those 2 weeks, have to give them those 2 week back, even though they paid for it. So in essence, they would be getting 4 weeks for the 2 weeks they took off. They got paid for the 2 weeks, and then they get 2 weeks more. So I don't know how
This is
that
kind of
works with
like what
this.
happened with the college thing where some people got paid to go got their bills paid and some didn't. You know,
Oh, yeah.
it's kind of like that weird. It's like when a new law comes in, some people are like, well, that didn't apply to me and I just was there, and the new people score. And so it's kind of that weird wonky time frame, isn't it?
Yeah, I kind of think I really would have to delve deeper into this law to see whether there's a requirement by the state that the employers give them these 2 weeks. Um, Maybe there's not. And if not, then the employer would have depending on their policy, or employers might try start changing their policy and say, well, if you go out on PFL, those first 2 weeks, we're not going to pay anything. You can just
So
take
this
the
is going
time
to
off.
be different according to each business. That's the thing. It's going to be according to what
Oh
they've
yeah,
done.
certainly. It
Who
depends on their policies. Yeah.
everyone is going to be different. So I always want to say that when we talk on these shows, it's like, here's some general guidelines of what's going on, but each business is different. Each situation is different. each county, city is different in California as well. So that's important too. So let's talk about leave for victims of crimes. So that's a new one too.
You know, what they've done is expand it. There has been leave for those who suffer domestic violence, sexual assault, stalking. They could take sick leave for those
Mhm,
bad events that have happened in their lives.
mhm,
Um, and now they've expanded that to other types of crimes, crimes where there's bodily harm, threats with weapons, threats of bodily harm, and so that could be many different crimes that are in the criminal statutes. So it's not saying, well, it's just this kind of thing or that kind of thing. Or this kind of criminal statute. It's this type of criminal statute where there is bodily harm alleged, threats of weapons, threats of bodily harm,
mm.
and so that could
Yeah.
be many different crimes that the DA might allege.
Well, I got robbed at gunpoint in my car and
Hmm.
I went wonky for a little while.
Yeah,
Like, because
you would
every
be
time,
able to take time off for this.
because I was weird driving, because it was an incident where I went to close the door and the guy had the gun literally, I could feel it in my head, you know. But
Yeah,
I did
wow.
chase him down later. But anyway, that's a whole other story. And then I almost got shot. So that was dumb. And then later freaked out. Like later kind of got wonky and I went to work, but I freaked out going to work, driving, stopping the stop sign because I realized anybody could stop me and just shoot me. That's how I felt.
Mhm.
PTSD wise, right? And I didn't realize I had that. And then a coworker was like, "You're going to drive to my house. You're going to have dinner with my wife and I. We're going to play some music because we're all musicians. You're gonna drive, and it's going to be at night. And you're going to do it, and you're going to go in a bit of the backwoods. This is in Florida. You're going to do this, and you're going to get home. But the time you're done, you're going to be okay." And I was. It took me. It it was hard, but once I went through it, I was like, yeah, yeah. You can't live your life in fear, but it takes. I wasn't normal, and I was not good at work. Honestly, I was not good at work because I suddenly feared everybody and everything. Because once someone can just encroach on your territory with a gun in your head, you are not normal. You are not normal. So I know people may think that law is weird, but you need a little time, but you also can't have so much time that you just make it worse. I don't know how to explain that. I'm not a shrink
Yeah.
or
Now
sorry,
the
I
law
shouldn't have
doesn't.
said shrink. I shouldn't have said that. Sorry. Let me
Yeah.
be politically correct, a therapist. I'm not anybody who knows anything other than I was not right after that for a few days, but I got over
Yeah.
it.
So the law won't address the length of time. Other than that,
Oh,
you're allowed up to 12 weeks. It's under the California Family Rights Act, which
wow.
allows 12 weeks. And so that's probably a decision that will be made by a physician.
Circumstance.
A circumstance, and a physician may say, "Hey,
Yeah,
they
if you're
really
getting
have
stalked,
PTSD."
yeah, if you're getting stalked or you have a harasser, yeah.
Sure. And the other thing about this law, it's also enforceable as a violation of the Employment and Housing Act. And so it can be, it's a violation of that act if you don't give them the leave to which they're entitled. And that has other types of damages, pain and suffering, other things involved. So you could file a lawsuit for this violation and be protected under that code section, Fair Employment and Housing Act.
Wow. How many employees do you have to have this? Like,
Uh,
is this,
five, the minimum of five.
oh, so small employee,
Yeah,
the
even
small employer,
yeah,
like,
because they
yeah.
changed the laws a few years ago. It used to be 50 or more, for, at least for the California Family Rights Act, and then they reduced it down to five. And the
Wow.
Fair Employment and Housing Act has always been five. So
It's so
yes,
weird that it's employee fair housing act has to do with employment law. It always cracks me up about that. It's like,
Well, they
Housing.
combined yeah, it does seem weird because it's Employment and Housing Act, but the idea was it's about discrimination and you can be
Mm.
discriminated against in employment and in housing. So that's why they lumped it together.
Oh, okay. Okay, minimum wage. We got to go there because,
Yeah, we do.
man, Ward, you've been on our shows. What? This is our 14th, 18th year. I think you've been on our shows for over 10, 12, 16 years. You've been on our shows over 10 years.
Yeah, over 10. Yeah.
Is it? Or getting to 10? Around there. Yeah.
Yeah, I think it's more
Yeah.
than 10. I think 2013 might have been the first year.
Wow. We're so much younger. Do you feel younger? I do. We feel younger. But minimum wage was coming up at the time when you first started coming on our shows.
Yeah.
And it's not ending. It's the never ending world
No,
of
I
minimum
I
wage
remember
and salaries.
saying in I think it was 2015, this is the year of the minimum wage. Maybe it was 2016, one of those years where when the big minimum wage law, well,
That's
when
why
minimum wage
2016 stuck in my head. Yeah, that's exactly the year when you started. That's it. Exactly.
and we talked about it some before, but it was moving way more slowly than it is now. And since that time, which I think was 2016, that
Yeah.
new law passed. And ever since then, minimum wage has been going up regularly.
I remember you going, this is coming, y'all. Just remember. See, I'm still
Yeah.
yawling. But yeah, you really gave people a heads up. It's coming. Don't think it's not going to happen. And it's happening. And it did. And so minimum wage goes up every year. And that also includes also salaries change according to minimum wage, the Minimum Wage Act as well. And then what's happening with the whole fast food thing? What's going on with that? Like the fast food? Yeah.
Salary first, and then I'll talk about the fast food.
Yeah.
Uh, the salary is based on the California state minimum wage. It's not based on municipality minimum wages. So even though San Diego has 17.25 as the minimum wage,
Wow.
the way you determine the minimum salary is by using the 16.50 per hour of the state of California minimum wage. Now, moving to fast food,
So
um,
that's where we're at. California as a whole is 1650, San Diego 1725.
yes, and
Wow.
other cities have different minimum wages
What
throughout
about
California.
salaries? Salaries changed?
Well, they don't change with the city minimum wages; they change with the state minimum wage. So the salary we have now that required to be an exempt employee. So if you're paying someone as an exempt employee, you have to pay them at least $68,640 per year. Now, you did mention fast food, and that sort of segues into what we've just been
Wow.
talking about because the fast food minimum wage is $20 per hour, and that makes the minimum wage or minimum salary for fast food employees, if you want them to be exempt employees, to be 83,200. It's a lot of money.
I'm just shutting up right now. I'm just shutting up. I'm just gonna shut up. Sometimes I'm told to shut up and I'm gonna shut up right now because but I'm not going to. I'm not. So fast food can override someone building a house. So we're now saying that this is almost a protected class of worker.
They're
Am I in
they
trouble? Should I shut up again?
no, that's not a bad way to put it. I wouldn't call it a protected class because normally we reserve that term for violations of the Fair Employment and Housing Act, when, the protected class
Disabled.
is race, gender, et cetera, et cetera, et cetera. Um, but here they have fast food workers have been singled out to get greater minimum wage and greater minimum salary than other industries.
So a teenager can get more at McDonald's than a Walmart greeter that is in their 60s just trying to get some extra cash from their
Certainly
social
possible.
security.
Yeah, it's certainly possible.
Okay. I'm not going to comment.
Okay.
And you're
We're
sitting
gonna
there
hold.
looking at me like this is a really weird thing when Lisa shuts up. Okay, next next on the agenda. Holy cow. No, I'm going to be very good. Driver's license restrictions. If you're in fast food, you don't need one unless you're driving
Probably
a
not.
car.
And that's the whole point. Employers cannot advertise jobs that require driving as part of it unless driving's an important component of that job. So if there's some, residual driving, you can't put it in there.
If
If
you're
there's no
delivering
driving,
pizza
well,
from the fast food place,
yeah, now if it's a driving job, obviously you can put that
you
in there
get
and say,
double
hey,
minimum wage.
yeah,
Sorry.
you can say you need a driver's license. But I think the reason why they did this, and this is something I just thought up on my own, was that they can cut out groups of people from these jobs by just saying you need a license. And so they don't want that to happen anymore.
Okay. Mm. This is very interesting. Is this a, you are on a border. So does that have to do with it? Do you think? No? Should I
But
not
that's the
go
whole
there?
state of California. No,
Yeah, you got a big border. You got a ocean.
I mean, you could say that people who come across the border and haven't gone through the proper channels, maybe it's harder for them to get a driver's license,
Hmm.
and therefore California is saying, well, we want to help those people. I mean, maybe, but certainly they don't want people who don't have driver's license to be prevented from working in jobs that don't really need them to drive.
Okay, so let's move on to voluntary captive audience meetings. And this is something I actually brought up with you years ago, and now it's coming around to be true. Like
Yeah, I
you
remember you
can't,
talking about this. Yeah.
I know. I talked about someone and you're like, yeah, no, no. And now it's here.
Yep.
So, and it's coming, there's other things coming down the pipeline, I believe. It's, I don't know. I don't know. But so an employer shouldn't be spotting unless it's a political company, right? If you're selling political gear, you shouldn't be forcing your employees to talk about what, well, I don't know. I'm gonna, no, I should just shut up. See,
Yeah,
I was
let
doing
me
good.
help
I
you
was
with
shutting
this.
up. I was shutting up really well, and I just can't handle it for very much long. Like I'm not good at that. So anyway, handing it over to you. What is this? Like people need to watch what they say, right?
Well, yeah, that's different though. This is saying that employers aren't allowed to require employees to attend meetings where the employer wants to discuss politics or religion. Because
Mm,
some employers, I don't know how many. I mean, honestly, I don't know any employer who does this, but I guess some employers will say, hey, I want to discuss this bad law that the legislature is coming up with, and I really would like everyone to write to the legislature and stop it.
mm.
And
I
so
have. I'm sorry, but I have, and I do know employers who have done. We're going to have a prayer meeting before work.
that would be another one. You can have a prayer meeting, you just can't require people to attend.
So yeah, it's that, and then there are political things where they rant and rave about something even for like against minimum wage and require their minimum wage workers to listen in about how angry they are and do something about it.
That could happen. And again, I have not seen that or heard it from any of my clients, but yeah, sure it could.
And so now it's illegal.
Yeah, you can't require them to. You can have the meeting, you just can't require them to attend.
When does it be, when do, okay, wait a minute. I just said it's illegal. When does something become illegal versus you're not supposed to do that? You're breaking a law versus illegal.
Well,
What is illegal
if you
actually at the end
said
of the day?
everyone has to attend my religious prayer meeting, that would be illegal because it violates
So it's
this law.
breaking the law. So as soon as you break a law, any law, it's
Yeah.
illegal.
Yeah.
Oh, oopsie. Okay. I didn't say I broke any laws. I'm just saying oopsie. You know? But wow, so interesting. So very a lot of laws protecting employees this year as before.
Every year.
I said as before. But it's like heightened, huh? It's heightened. But then if you think about it, some have actually, it seems like so when we first talked, it seems like some laws, the employers said, hey, this is not working, the PAGA thing, the Private Attorney General Act. So that seems like they got some feedback. And
Do
so
employers get relief sometimes? Sure. Yeah.
so they did get some relief. So how, just in closing, how when employers are feeling the burden, do they have to go back? When we talked about freelancers and independent contractors, Uber and Lyft and everyone got together and started their whole thing together, even though they're competing companies, to just say, hey, this is, you know, crazy. But what happens to employers, small people, especially small businesses, right? That should be the backbone of this country, but they're really trying hard to still be. How do they fight back on some of these laws? Do they have to do bills? Do they go to attorneys? Do they, I mean, they don't have,
I mean, I think the most effective way and the normal way is through the Chamber of Commerce, your local Chamber of Commerce, because I know
okay,
the San Diego Chamber of
that's
Commerce
good to know. Yeah.
has many small businesses
They have legal
that are
sides too.
part
Yeah.
of it, and then they will go address these bills. The
Wow.
Chamber of Commerce will.
Yeah. You got to, and I want to say with that, go beyond. If you're in an unincorporated area, go to your bigger city like San Diego and stuff like that to make sure that that happens, like what you're talking about, because the bigger chambers really do represent,
Oh, they do. I'm a member of the Chamber of Commerce. I love it. I think they do great work. I've gotten lots of clients from it. I like it, and I represent
Mhm.
employees too. But in terms of meeting employers, it's just a great thing, and they do necessary work. They really do.
Mhm. They do. They do. I agree. I agree. Ward, we did the big one. Anything else to add to it? I thought we did good.
I don't have
Any,
anything else to add. No, there are some other laws that have changed, but I try to pick the ones that I think might apply to the general business community. So
well, we'll
nothing
be
else to
back on the
add.
fourth Wednesday as always. So everyone, best employment attorney San Diego.com. Look, I don't even have to read this after all these years
I
on
know,
that
you know it by
website.
heart.
Well, it's a good website name, right? And
It
of course,
is.
go to blendradioandtv.com. You can read Ward's articles there and listen to his past podcasts. But this is always a great start to the year for employers and employees to know. And thank you so much, Ward. Happy New Year. And let's hope everything goes well in LA and like gets better soon, quick,
Yeah,
as
and we'll
we air
visit about
this.
that again at the end of the month. So I'm looking forward
Absolutely.
to that.
Thank you.
You're welcome.
Thank you for listening to Big Blend Radio's California Employment Law Podcast with San Diego attorney Ward Heinrichs. Keep up with Ward at bestemploymentattorneysandiego.com or follow him on LinkedIn, Facebook, and Twitter. You can also subscribe to Big Blend Radio at bigblendradio.com.